ball of a day's play.
I'm afraid we have some
surrounding Shane Warne,
the former Australian leg spinner,
the greatest spin bowler in cricket history, Shane Warne,
has died suddenly. A legendary cricketer. He was only 52 years old, widely regarded as one of the greatest bowlers of all time.
Shane Warne's $20.7 million fortune was divided in a way that left his ex-wife and former fiancée with nothing. But was he justified?
Passing of Australian cricketing great Shane Warne, details of his will,
almost $21 million,
have been released by the Supreme Court.
When cricket legend Shane Warne tragically passed away in 2022, he left behind a multi-million-dollar fortune. But the distribution of his $20.7 million estate didn't go as some might have expected. Despite a $10 million divorce settlement with ex-wife Simone Callaghan years prior, Warne made the controversial decision to exclude her from his final will. His former fiancée Elizabeth Hurley was also left with nothing. So where did Warne's millions go instead? As a lawyer with over 20 years of legal experience, I find these high-profile estate distribution cases super interesting because they rarely go as straightforward as you think. So in this video, we're going to do a deep dive into some of the shocking decisions Shane Warne made with his multi-million-dollar estate. Decisions that raised a lot of eyebrows and likely weren't what you'd expect from a global superstar. And perhaps most importantly, I'll break down the crucial lessons you can learn from Warne's estate planning decisions. Lessons that could save your own family from nasty legal battles and endless drama down the road. Now before we dive into the controversies, let's first look at a specific breakdown of Wayne's $20.7 million estate and how it was divided. The bulk of Wayne's wealth, $6.4 million each, was divided equally among his three children, Brooke, Jackson, and Summer. This means his kids collectively received over $19 million, or roughly 93% of the total value. But the children weren't the only beneficiaries. Wayne also allocated 2.5% shares worth around $500,000 each to his niece Tyler and nephew Sebastian. His younger brother Jason, with whom he shared a close relationship, received a 2% portion. As for hard assets, Warne left his valuable car collection comprising a BMW, Mercedes-Benz, and Yamaha motorcycle worth an estimated $375,000 to his son Jackson. The remaining millions were held in an Australian bank account, investment portfolio, and other personal belongings and property. This included Warne's $6.5 million home in the affluent Portsea suburb of Victoria. But there were some key individuals conspicuously missing from his final will and testament. Despite being married to Simone Callaghan for 10 years and sharing 3 children together, Warne made the bold choice to completely exclude her from his will. Even more surprising, his former fiancée and high-profile actress Elizabeth Hurley was also left with nothing. Now you might be wondering, why would Warne make such a controversial decision? Well, there are a few potential reasons to consider. Firstly, when Warne and Callaghan divorced in 2005, they reached a substantial settlement agreement. Callaghan reportedly received a payout of around $10 million at that time. So it's possible Warne felt he had already sufficiently provided for his ex-wife financially. There's also the fact that Warne and Callaghan had a highly publicized and tumultuous relationship. They initially separated in 2002 after allegations of Warne's infidelity, before eventually divorcing a few years later. The strained nature of their relationship could have influenced Warne's decision to cut ties completely in his estate planning. As for Hurley, while they shared a high-profile engagement in 2011, they ultimately called it quits and ended their relationship in 2013. With Hurley being a successful actress in her own right, Warne may have felt that she didn't need or expect any inheritance from him. It's worth noting that Warne did have the foresight to update his will just 3 months before his unexpected passing. This means his choices were likely intentional and reflective of his most current wishes. Now, of course, we can't know for certain the exact reasons behind Warne's decisions, but it's clear that his relationships and past history with his ex-wife and ex-fiancée played a significant role. This might seem like a highly unusual move on Warne's part, but the reality is, it's not as uncommon as you might think. In my experience as an estate planning attorney, I've seen countless cases where divorced individuals intentionally leave their former spouses out of their wills. In fact, data suggests that around 60 to 70% of divorced people do exactly that. There are a few key reasons why this tends to happen. For starters, once a divorce is finalized and assets divided, many feel that they've already given their fair share to their ex-partner through alimony or settlement payments, so they don't see a need to provide for them again in their will. Additionally, the emotional turmoil and breakdown of trust that often accompany a divorce can make someone quite resolute in their desire to completely sever financial ties. The thinking is, we've moved on, so why should you still benefit from my estate? It's also quite common for new marriages or relationships to influence a person's wishes. They may choose to leave everything to a new spouse or family instead of making provisions for an ex. From a legal standpoint, in most jurisdictions, an ex-spouse has no automatic claim to your estate once your marriage has been officially dissolved. In New South Wales, a divorce does revoke parts of the will, including assets distributed to former spouse and the appointment of them as an executor, trustee, or guardian. Now, of course, that doesn't mean an ex-spouse can't choose to contest the will in court. If they feel they've been unfairly left out, or if the courts believe that your intention was to leave a gift to your former spouse, then the gift will still be considered valid and your spouse will get to inherit. But the odds tend to be stacked against them, especially if proper estate planning was done. Speaking of contesting wills, while it may be common to exclude an ex-spouse from your will, that doesn't mean that there aren't potential legal risks involved. Warne's case actually highlights some important considerations in this area. You see, many jurisdictions, there are certain classes of people who may have grounds to contest or challenge a will if they feel they've been unfairly left out or inadequately provided for. This typically includes current spouses, children, and any financial dependents. The laws around this vary, but generally a court will look at factors like the size of the estate, the beneficiary's financial needs, their relationships and contributions to the deceased, and whether the will maker's intentions seemed reasonable. So in Warne's situation, while his ex-wife Simone likely didn't have a strong case, due to their past divorce settlement, his children theoretically could have contested his will if they felt the distributions were unfair or didn't provide for them. Fortunately, that doesn't seem to have been an issue here, but it does underscore the importance of being very intentional and strategic when excluding certain beneficiaries. Proper documentation and estate planning are crucial to back up and legitimize your wishes. Which brings us to the final key takeaway from Shane Warne's high-profile case. The lessons it offers for all of us on proper estate planning. The first key takeaway: regularly updating your will and estate planning is absolutely vital, especially after major life events like marriages, divorces, births, or deaths in the family. Wills are not static documents. Your beneficiaries and intentions can change dramatically over time. As we saw with Warne, he had the foresight to update his will just 3 months before his unexpected passing at the age of 52. This ensured his most current wishes were documented and less susceptible to challenges. Don't make the mistake of letting old wills with outdated information linger. Next, if you plan on excluding certain individuals like former spouses or estranged family members, be extremely intentional about your reasoning and document it thoroughly. This creates a clear record and paper trail that can be invaluable if your will is ever contested. It shows your decisions were purposeful and not made lightly or due to undue influence. Now, additionally, while it may be uncomfortable having candid discussions with anyone you plan on disinheriting, it's highly advisable. Give them a heads up about your plans and explain your reasoning. This upfront approach, while difficult, can prevent bitter surprises and knee-jerk legal challenges later. Ultimately, you do have the right to distribute your estate however you see fit, but there are smart ways to protect that wish and prevent any nasty legal battles after you're gone. Shane Warne's case provides some powerful lessons on the importance of proper estate planning. But let's face it, handling the details of wills, inheritance, and estate distributions is not easy, even for the wealthy and famous like Warne. There are many legal pitfalls and family dynamics to consider. That's why if you truly want to safeguard your legacy and ensure your assets go precisely where you intend after you're gone, working with an experienced estate planning lawyer is absolutely crucial. Trying to figure it out all on your own opens you up to costly mistakes and potential challenges, which is why I like to extend a personal invitation to book a consultation with me and my team. We'll do a deep dive into your unique situation, your assets, your beneficiaries, and your specific wishes. And we'll craft an airtight, comprehensive estate plan tailored just for you. Getting started is easy. Just click the link I've left in the description below to schedule your private consultation.